You are 3 sentences away from making a statement that follows you into a courtroom. That is exactly where you sit when a uniformed officer leans into your window on a quiet street in any city in this country, radio crackling on his shoulder, and asks 4 soft words. Where are you headed tonight? You pulled over calmly. You have your hands on the wheel. You are 2 blocks from your own driveway. The officer's name tag says Constable Singh. He leans in with a relaxed, friendly smile and does not ask for your documents first. He asks where you are headed. 4 words. And most Canadians, good, honest, well-meaning Canadians, answer that question immediately. They answer it the way their parents told them to. They answer it because they believe cooperating is the same as being innocent and that innocent people go home faster. That belief has put more Canadians into evidence folders than almost anything else I have seen in this work. There are exact words that flip this moment, words the Canadian Charter of Rights and Freedoms is entirely on your side about, words that turn a fishing expedition back into a routine stop. Say them correctly, in the right order, and the officer has to move on. Say them wrong, or leave out the one piece that comes after them, and every protection you just invoked collapses as if you had said nothing at all. That is what we are here for tonight. The officer's body camera is recording, his vehicle dash cam is recording. Whatever leaves your mouth on that street is in the record permanently. It is going to sit in a disclosure package with your name on it long after you are home and asleep. You do not get to be casual. You do not get to explain. You get one thing, a memorized line, a clean delivery, and one final piece that almost nobody knows about. The piece that determines whether everything you just said holds or quietly falls apart. Let us get into it. 99 drivers out of 100 staring at Constable Singh's relaxed face do the same thing. They answer, just heading home, coming from a friend's place, grabbed a couple of drinks after dinner. They think they are being polite. They think cooperation closes the encounter faster. They think the honest, straightforward answer is what a person with nothing to hide would give. That is the advice everybody grew up with. And it is the most expensive instinct a Canadian can carry into a police stop. It is not you that is the problem. It is the advice. I spent years on one side of this. I understand how these encounters are structured, why they are structured that way, and what makes them fall apart. The answer to where are you headed was frequently the moment that opened every door that needed to stay closed. Now I work on the other side, defending people who gave that answer and are sitting across from me trying to understand what went wrong. I am not going to make you wait 20 minutes for the words. You get the words first. That is the deal. In about 2 minutes, you are going to have one memorizable sentence. The exact words you say when Constable Singh leans into your window. Then I am going to show you the actual charter provisions and Canadian court decisions behind every clause of it. Then the 4 things the officer does next and exactly how to respond to each one. Then the single mistake that almost every person makes that voids everything they just said. One mistake. After saying the words perfectly, that kills the whole thing. Words first. Here they are. Constable Singh leans in, shoulder radio on, 4 soft words. Where are you headed tonight? You keep both hands visible on the wheel. You look at him directly and you say, word for word, Constable, I am going to exercise my right to remain silent. I will provide my license, registration, and insurance. I do not consent to any searches. And I would like to speak to a lawyer before answering any questions. That is the sentence. Memorize it exactly. Not the concept, not your version of it, that sentence in that order. Because every clause is doing a specific, legally distinct job, and removing any single one of them opens a door you just worked to close. Say it out loud once right now before we continue. Now the delivery, because the words only work in one register. Calm, respectful, direct, firm, not aggressive, not sarcastic, not nervous and stumbling, the tone you would use at a government counter asking a bureaucratic question. Because the moment that camera picks up attitude or agitation, the notes say uncooperative and the narrative around everything that follows shifts accordingly. Every person reviewing that footage 6 months later watches it through that frame. Firm is your ally. Rude is his. Say it like you have said it 100 times before and mean every word of it. But before we go into the proof behind each clause, I need you to hear something. I have watched people say every single word of that sentence correctly, cleanly, on camera, and still hand over their entire case afterward because of one thing they did 6 seconds later. We will get to that. It is the most important part of this entire video. First, the proof. Start with what the Charter actually says, because everything downstream flows from this. Section 7 of the Canadian Charter of Rights and Freedoms. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Section 8. Everyone has the right to be secure against unreasonable search or seizure. Section 9. Everyone has the right not to be arbitrarily detained or imprisoned. Section 10. Everyone has the right on arrest or detention to be informed promptly of the reasons therefor, to retain and instruct counsel without delay, and to be informed of that right, and to have the validity of the detention determined by way of habeas corpus. And Section 11C. Any person charged with an offense has the right not to be compelled to be a witness in proceedings against that person in respect of the offense. These are not suggestions. These are constitutional guarantees that apply the moment Constable Singh flipped those lights on and you pulled over. The moment you stopped at his direction, you were detained within the meaning of Section 9. That is not an opinion of the Supreme Court of Canada, confirmed in R.V. Grant 2009, that a detention occurs when a person is legally obligated to comply with a police direction or reasonably concludes they have no choice but to comply. You pulled over because you understood you had no choice. That is a detention. The Charter turned on. And when the Charter turns on, something specific happens that almost nobody knows and almost nobody tells you. The rights attached to that detention are not automatic in the sense that they operate invisibly in the background protecting you. They are rights you have to invoke. That is the architecture. The Charter gives you the tool. You have to pick it up and use it. And the way you use it is with specific, audible, on-the-record words, not body language, not silence, not hesitation, words. Now, Constable Singh stopped you for something specific, a traffic matter, a tail light, rolling through a stop. Whatever it was, that is the lawful basis of the stop. That is the only lawful basis. Where you are headed, where you came from, who you were with, how many drinks you had, none of that is connected to the reason for the stop. Those questions are not part of the traffic stop mission. They are a fishing expedition attached to it. And the Supreme Court of Canada has addressed what happens when that fishing takes longer than the traffic matter it is attached to. R.V. Mellenthin, 1992, established that routine traffic stops cannot be turned into a general inquiry into the vehicle or its passengers. The stop has a defined scope. Questions beyond that scope are not compelled. R.V. Mann, 2004, confirmed that the scope of a detention is limited to its purpose and that investigative steps must be tailored to the specific circumstances that justified the stop in the first place. The officer has a job to do. The job has a defined perimeter. Questions about your social life, your destination, your recent activities are outside that perimeter. So when you say, Constable, I am going to exercise my right to remain silent, you are not being difficult. You are declining precisely and surgically the category of question that has no connection to the lawful purpose of the stop. Every second the officer presses on it, he is on the wrong side of Mellenthin. That clause closes one door. The next one closes the door most people walk right through. I will provide my license, registration, and insurance. This is the clause that keeps you from being accused of obstruction for asserting everything else. Provincial traffic legislation across Canada requires a driver to produce these documents on lawful demand. When you offer them before he even asks, you are checking the one box the law requires, and you are doing it visibly and voluntarily on camera, cooperative, on the record. That ends any narrative about you being obstructive or evasive before it can begin. You are complying with exactly what the law requires. Anything he asks beyond that is a request. And in Canada, You are not legally required to answer police questions if you are not under arrest. That is not a legal gray area. The Supreme Court of Canada confirmed in R v. Sinclair 2010 and in the common law principle against self-incrimination that the right to silence is a fundamental legal right available to any person who is questioned by a person in authority. You have it. It applies here. Which brings us to the most expensive sentence Canadians say at traffic stops. It is not a formal statement. It is a shrug and the word sure, go ahead, I do not have anything to hide. Section 8 of the Charter protects you from unreasonable search and seizure, but the word unreasonable carries enormous legal weight here. The Supreme Court of Canada in R v. Wills 1992 and affirmed repeatedly since has established that a search conducted with valid consent is constitutionally reasonable regardless of whether the officer had other grounds for it. Translate. The moment you say yes, the moment you wave at the back seat, the moment you step aside and say go ahead, the constitutional protection is gone, you handed it over. And you were not required to. You were not told you could refuse because in Canada, as in most jurisdictions, there is no obligation for an officer to inform you of your right to refuse a consent search in that moment. The burden of knowing rests on you. So the words have to be clean and specific. I do not consent to any searches. Not I would rather you did not. Not I do not think you have grounds. I do not consent to any searches of me, my vehicle, or my belongings, because a partial refusal, a vague one, or a qualified one leaves open every dimension you did not explicitly close. A vague statement about not wanting someone to look in the back leaves the front console inside the consent bucket. A refusal that mentions the trunk leaves the passenger cabin open. The courts assess consent by what was communicated, and partial communications leave partial protections. Say it once, say it completely, say it precisely, and now the constitutional burden is exactly where Section 8 intended it to be, on him to establish grounds, not on you to volunteer cooperation you were never required to provide. The final clause is the one where most people's invocations quietly collapse before they even know it happened. I would like to speak to a lawyer before answering any questions. Most people believe that staying quiet is enough, that crossing your arms and not answering questions protects them. The law in Canada is more specific than that, and the failure to understand the specificity has cost more people than I can count. Section 10b of the Charter gives you the right to retain and instruct counsel without delay upon arrest or detention. That right must be asserted. The obligation to hold the inquiry is triggered by the invocation. In R v. Bartle, 1994, the Supreme Court of Canada confirmed that once a detained person invokes the right to counsel, the police are obligated to facilitate that right and must hold off on questioning until the person has had a reasonable opportunity to speak with counsel. The invocation activates the protection. Silence without invocation does not engage the same obligations. This is critical. The prosecutor's job, if it ever gets that far, is to use your demeanor, your gaps, your pauses, your non-answers against you. An invoked right to silence is a legal shield. Unexplained silence is a vacuum that gets filled with whatever narrative serves the other side. Say the words out loud, on camera, on the radio, on the record. I would like to speak to a lawyer before answering any questions. That invocation engages Section 10b, triggers the obligation to hold off on questioning, and sets up every suppression motion your defense lawyer files months later if the investigation continues. 3 clauses, 3 charter protections, 3 Canadian court decisions doing the work. Now let me tell you where you headed tonight actually is. That question is not small talk. It is an opener taught in investigative technique training precisely because it is so disarming. It is designed to do several things at once. It gets you talking so that your affect, your tone, your coherence can be assessed. It locks you into a version of events before you have had any opportunity to think carefully about what you are saying. And it opens the door for follow-up questions that require your cooperation to pursue. The question is framed as friendly so that declining it feels rude. The officer does not need you to confess. He needs you to seem nervous, evasive, inconsistent. Anything other than a clean, confident, politely unmovable citizen who knows exactly what the law says and is exercising it precisely. Break the technique, not the badge. The officer doing his job is not the problem. The instinct that trained an entire country to believe that answering questions proves innocence is the problem. You cannot explain your way out of a fishing expedition. That is the first false exit. You think if you just say, I was at my cousin's, we watched the game, I had 2 beers, and I am totally fine, the officer will close his notebook and wave you off. He will not. Every sentence is a new fact he did not have before. Every new fact is either verifiable or useful or both. You have expanded the investigation with your own words. An experienced interviewer does not hear your story and conclude innocence. He hears your story and notes what to check. He checks the detail about the cousin. He checks the detail about the game. He looks for the inconsistency between what you said and what your passenger said, if you have one. He looks for the version of your story that does not match what the investigation later reveals. You thought you were closing the conversation. You were opening a file. You cannot just go quiet either. That is the second false exit. Silence without a clear invocation leaves a gap that gets interpreted and narrated. Your demeanor fills it. Your hesitation fills it. The pause between questions fills it. Staying quiet without invoking is treated in law as behavior, not as a right being exercised. In a hearing later, the question becomes, why did you not answer? And the answer you should have given is, I had invoked my right to remain silent. An invocation you never made out loud is an invocation no one can verify.
No, I was not.
The Crown's position becomes he chose not to answer the officer's questions. There is no charter-protected silence without the words to anchor it. And you cannot act natural because nothing about a police stop is natural for your nervous system. Your voice changes, your hands move differently, your eyes track in ways that experienced officers have been trained to observe and note. The report does not read nervous, it reads signs of deception. It does not read shifty eyes, it reads evasive demeanor. The encounter does not need you to confess to anything. It needs something to work with, talk, wait, or react. Each of those gives it something. The memorized sentence is the only exit that closes all 3 doors at once. I will be straightforward with you about what this achieves. Saying these words tonight might not end the stop. It probably will not. He may still write the ticket. He may still make another request. The win is not on the street under the streetlight with his radio going. The win is in a courtroom hearing months from now where the fight actually belongs. The roadside is where you survive. The courtroom is where you prevail. He is going to push back. The first push is the guilt frame. It comes almost word for word every time. Look, if you do not have anything to hide, why not just let me have a quick look? That question is a trap shaped like common sense. Answer the framing and you have already lost. You either agree that you have something to hide or you consent to the search. Do neither. You say, Constable, I am not saying I have anything to hide. I am saying I do not consent to searches. Am I free to go? Read what that response does. It refuses the false binary. It restates the consent refusal clearly and explicitly on the record because consent must stay clearly refused to remain effective. And it flips the detention question back to him. He now has to answer, either release you or detain you and be prepared to justify the grounds, firm, polite, recorded. He may tell you to step out of the vehicle. This is where some people hurt themselves by resisting based on something they read online. In Canada, under provincial highway traffic legislation and the common law, an officer can lawfully require a driver to exit the vehicle during a lawful stop. Refusing to do so is a separate problem. You comply every time, but you comply with your rights still working. You say, yes, Constable, you unbuckle, you step out, you keep your hands visible. And once you are standing on the curb, you say clearly and calmly, I want to be clear that I am complying with your direction, but I do not consent to any searches of me, my vehicle, or my belongings. You did the lawful thing. You restated the constitutional thing. Both are on the record. Now he has to justify whatever comes next. The temperature may rise. He may say he smells something. He may say he is calling for a drug recognition officer. He may say that based on your demeanor, he believes you have been drinking. Do not argue the smell. Do not deny the smell. Do not explain. You say, Constable, you do what you feel is necessary. I do not consent to any searches. That is all. His claim of reasonable grounds is a legal argument for a later proceeding, not a conversation to have at the curb at 11 at night. If he has genuine grounds, he can act on them. And if he did not, that becomes the foundation of every motion your lawyer files. The clock matters here too. R.V. Grant established that the longer a detention continues beyond its lawful purpose without escalation to arrest, the more rights implications accrue. Every extra minute on a routine traffic stop that is turned into an interrogation is a minute that works against the state's position in any subsequent hearing. When the documents come back, when the citation is processed, when the momentum of the encounter has stalled, you close with the most useful question in any Canadian police encounter. Constable, am I being detained or am I free to go? Section 9 is now in his lap. He has to choose. If he says you are detained, he needs articulable cause and he will have to justify it later. If he says you are free to go, you leave. You do not linger to thank him. You do not say anything further. You put the vehicle in drive. Every protection holds, unless you make the mistake. Here it is. The mistake is not a legal word you got wrong. It is not a phrase you misremembered. It is the 6 seconds after you said everything correctly when Constable Singh pauses, drops his tone, and asks something quiet and human. Long shift, eh? You work around here? You okay? And you answer. Just once, just to be normal, just because silence felt rude. That is the void, and it swallows everything. Section 7 of the Charter protects the right to silence as a principle of fundamental justice.
I'm not sure.
But that protection applies to what you say under compulsion, not to what you volunteer. The moment you voluntarily re-engage, you have done something legally specific. You have demonstrated that the invocation was not a clear, consistent exercise of your right, but a momentary position you were willing to abandon. In Canadian courts, the consistency and clarity of a right to silence invocation is assessed against the entirety of the person's conduct. One casual answer after a careful invocation does not just add a statement to the record, it recontextualizes the invocation itself. He did not beat your rights. He waited. He softened the temperature. He asked one human question, and your instinct to be a decent, normal person did the rest. Fraternization with the questioner is built into the technique. The friendly close is as deliberate as the opening move. The words hold only as long as your mouth stays closed after them. Not one sentence about the weather. Not one comment about your day. Not one thing about how long you have been driving. Say the words, and then stop. Full stop. The invocation lives only as long as you do not voluntarily contradict it. Here is the entire sequence in the order you use it. Constable Singh leans in, hands on the wheel. You say, Constable, I am going to exercise my right to remain silent. I will provide my license, registration, and insurance. I do not consent to any searches, and I would like to speak to a lawyer before answering any questions. If he pushes on the hiding something frame, Constable, I am not saying I have anything to hide. I am saying I do not consent to searches. Am I free to go? If he orders you out, yes, Constable. Then standing. I want to be clear I am complying, but I do not consent to any searches of me, my vehicle, or my belongings. If he claims grounds, Constable, you do what you feel is necessary. I do not consent to any searches. To close. Constable, am I being detained or am I free to go? Then nothing, not one more word. Here is the drill. Open your notes app right now. Title the note if I am stopped. Type those lines in exactly, all of them. Read them out loud tonight. Read them tomorrow morning. Read them again before you drive. Read them until they feel boring. Because the night you actually need them, boring is exactly what saves you. And remember, say the words, then stop talking. One important note, this is general legal information about your charter rights as they apply across Canada. Specific situations, provincial statutes, the duty to identify in certain circumstances, and other variables can affect how these principles apply to your exact encounter. For anything that has happened or is happening to you specifically, talk to a criminal defense lawyer licensed in your province. The best time to know this is before you need it. The second best time is right now. Your rights do not protect you because you have them. They protect you because you use them. Firm, polite, recorded. Say the words, then stop talking. That is the whole game. Now tell me in the comments, has Constable Singh or someone exactly like him ever leaned into your window and asked where you were going? Did you answer? Did it turn into something? Drop it below. Your scenario shapes which encounter I break down next. And if you have a partner, a teenager who just got their license, a friend who works late, a family member who commutes, send this to them today. Because where you headed is only the opening move. What comes after it, when the tone changes and the conversation moves from a request to a direction, that is a different rule book with different exact words. And the wrong response there carries consequences that go well beyond a traffic ticket.